Hey, this is Will at Downs Law. I wanted to talk briefly about construction liens. They're often called materialman's liens or mechanics liens or M&M liens, a variety of terms. But what they are is for contractors that don't get paid for performing work on certain jobs for a particular property, is you can file a lien against the property for the amount of the work. How do you do this, and what are the repercussions and implications? I want to walk through that real quick with you. All right, so materialman's liens, in Georgia, it's use it or lose it. What that means is that if you don't exercise your rights to file a materialman's lien, then you lose your right to do so. And the law is very strict about the procedures and mechanisms for filing these liens. And if you don't comply with every single one of them, then you lose your right to file the lien, to have it be a lien filed of record against the property. And so what are the things you need to do? Well, first and foremost, you have 90 days to file and record the lien from the last date of work performed at the property. And it's very strict 90-day requirement. And as a practical matter, that's not a lot of time, right? So if you're performing work on a job, it's very often the case that you might not get paid for 30 days. And then at that point, once you realize you haven't gotten paid, then you kind of engage in negotiations to try to get paid, and those can drag out, and you're very quickly coming up against the 90-day mark. And it's 90 days to actually have the lien recorded. And it's recorded in the county real estate records of where the property is located. And it used to be the case that you could mail in these liens, and it would take a week or 2 weeks for the clerk to actually record the lien. And so you would want to make sure that you mailed it out well in advance of the 90 days. Now these things can be filed online, so that is not as much of an issue. Typically, if you file online, they're recorded within 24 to 48 hours, but you don't want to go past that 90-day period. And it's 90 days from the last date of work performed or the materials were on site. Then, not only do you have to do that, but contemporaneous with the recording, you have to provide written notice to the owner of the property via certified mail or overnight delivery that the lien has been recorded. And so if you file the lien, but you don't send the notice to the owner, then the lien is going to be declared invalid. And you want to make sure you send it to the property owner. And the property owner may not necessarily be the person that hired you. You may be a subcontractor hired by general contractor, but you need to find out who the property owner is in order to provide them with the notice of the lien. Then you have 1 year to do what's called perfect the lien. And I always think this is a very confusing term. Like, what does it mean to perfect a lien? Nobody's perfect, right? But what it really should say, I think, is 1 year to file a lawsuit to get the money that's due to you, right? So that's what perfecting the lien means, is filing suit, whether that be in a court or arbitration, to actually get the money. To enforce your rights to get the money from whoever owes you that money, whether it be the property owner directly or the contractor, if you're a subcontractor. And then once you do file that action, when they're in the court or arbitration, you then have to do something else. Within 30 days of doing that, you have to record what's called a notice of commencement of lien action in the county land records. So the same place you file the lien, you have to file a document called a notice of commencement. And the notice of commencement has very strict requirements as to what needs to be in that. But basically, the sum total of everything is what you're trying to do is put prospective buyers or purchasers or lenders on notice that you have claimed a lien against the property. And so that's why these documents have to be recorded. That's why notice has to be given, is you're putting everyone on notice that you have a lien. So some common pitfalls in filing these things and filing liens are, number one, missing deadlines. So if you don't file the lien within the 90 days, of course, you lose your right to do so. You can file it late, but if it was contested, it would be declared invalid. Defects in what's contained in the lien, in the wording of the lien. So there's certain language that has to be filed in the lien, and it has to be a certain size font. If it's not that certain size font, then the courts can say, that you're not in strict compliance with the law, and therefore the lien is invalid. It seems like a very harsh result, but it's because liens are what's considered in derogation of common law. And so what that means is that there's a specific set of procedures for how to file these things. It doesn't exist in the law other than the statute laying out the procedures. And so therefore you have to follow it very precisely in order for it to be effective. The lien also must specifically reference the property or allow people to identify the property that is being liened. So you're going to need to either include a legal description or reference to the particular deed and book and page where the property information can be found, so that prospective purchasers or buyers or lenders can clearly identify the property that's being liened. And then not recording that notice of filing will certainly cause your lien to be defective. So in sum, these liens are very hyper technical, as I like to call them. There's so many things, so many ways you can go wrong, so many things that you can do that can make your lien invalid. Why go through all the trouble, right? I mean, what's the point of all this? Well, the real thing that they do is create what's called a cloud on the title of the property. Again, cloud is this, legal term, but what it means to create a cloud on the title is it mucks up the title, right? It creates an issue with the title. And if you're trying to sell your property or refinance, a lender, a title insurance company, a prospective purchaser isn't going to want to deal with that, right? They're not going to want to deal with a lien on the property. So that's your main advantage as a contractor in filing these liens. Is it is for the year that they're valid liens, it creates this cloud. It makes the property unmarketable, right? Someone's going to have to deal with your lien if they want to sell or refinance the property. But what they don't do necessarily is get you paid as a contractor, right? So a lot of contractors think, well, I have lien rights, right? I can file the lien, I'm going to get paid, slam dunk, no brainer, I don't have to worry about it. Well, as is often the case, when you file the lien, sometimes nothing happens, right? I mean, you may provide the notice and no one's ringing your phone to try to get you paid. And then you're frustrated and you're confused and you're like, well, I filed the lien. Well, filing the lien in and of itself, all it does, again, is cloud the title. But if the property owner doesn't care, if they're not trying to sell the property or they're not trying to refinance, then they're just going to let it sit there. And if they just let it sit there, that doesn't get you paid. So what do you have to do to get paid? You have to file that lien perfection action, right? The lawsuit or the arbitration to collect the money. And so if you have to do that anyway, why not just go ahead and do it, right? So my advice is generally if you're going to go through the trouble of filing a lien, then be prepared to immediately turn around and bring that lawsuit, say within 30 days of filing it. Because you only have a year to file the lawsuit or arbitration from when you file the lien anyway. The lien is only valid for a year. So if it's only valid for a year and you don't get paid right away, then odds are you're probably not going to get paid. So you might as well go ahead and initiate that collection action to get the payment. So, and then if you do get a judgment in a court for the money, then that also operates as a lien if it's recorded. And that lien is good for 7 years. So in the priority of liens between a mechanic's lien that's good for a year, but only if you then file suit, or court judgment, which is good for 7 years, certainly the one that ties up the property for longer is the judgment lien. So those are just it's kind of a quick overview of materialman's liens for contractors. Obviously, there's a lot more to it. It's very, like I said, hyper technical, and there's requirements for what the lien needs to say. So I would always advise contractors, if they're not familiar with the process, to consult with an attorney. We can certainly advise you on that at Downs Law. Our number is 404-842-6500, or our website at downslawllc.com. Thanks for your time, and I hope you found this informative and educational.